Imagine being at the center of a legal case that changed contract law. That's exactly what happened in Great Northern Railway vs. Witham back in 1873. This case not only shaped how contracts were understood, but also set an important legal precedent that established the legal validity of standing offers. The case involved a dispute around a contract. The Great Northern Railway Company advertised for tenders for the supply of iron goods for a 12-month period. Mr. Witham submitted a tender to supply these goods at fixed prices in such quantities as the company's storekeeper might order from time to time. Great North Railway accepted Witham's tender, creating an agreement for 1 year. After supplying some goods, Witham refused to fulfill a specific order placed by Great North Railway, arguing that because Great North Railway was not obligated to order all that iron from him, there was no consideration for his promise, and thus no binding contract. Great North Railway sued. The court needed to determine if a binding contract existed, specifically regarding whether Witham was obliged to fulfill individual orders placed after his tender was accepted. The court looked at the actions of both parties. Did Witham accept the terms? Were the terms reasonable and clear? The court held that the tender for the supply of goods was a standing offer. A standing offer is a framework for supplying goods or services at pre-arranged prices without knowing the exact volume or timing in advance. This meant that while Great North Railway was not obligated to order any goods, each time they placed a specific order, they accepted that part of the standing offer, forming a legally binding unilateral contract for the order. The court also held that the consideration for Witham's promise was the actual order placed by the company. When Witham submitted the tender, he promised to supply goods at a set price if asked. When asked to do so, he was legally bound to perform. In the end, the court ruled that a contract existed, and Witham was legally obliged to deliver goods ordered as per his tender. There was also ample consideration for the promise. Great Northern Railway vs. Witham is a classic example of a unilateral contract, where one party, Witham, promises to perform if another party, Great North Railway, acts by placing an order. So, what can you do next? Reflect on how these principles affect your contracts. Every agreement matters, and understanding your rights is key.